turn to this file. You have this file, this one.
Can 6 Milord possibly would be one of the applications, Milord?
Just give him the copy. Just take out this file.
Milord, it is in IA 87607, which is filed, Milord, day before yesterday possibly.
No application can be filed at this stage after the matter is post off.
87607.
Please study for the look. We have the copy of the minutes.
Yeah.
Dated 5th of May 2022.
Yes, that's the
Correct? That's a cabinet memorandum.
right.
On that basis, Milord, an application is made, Milord.
But I'm not concerned. I'm just going to the cabinet memorandum. If you have that, please take us.
Yes.
And how do we get into all this? Keeping in mind the constitutional provisions that aid and advice given by the Council of Ministers cannot be inquired into and gone into by the court.
My Lord, can you take up the cabinet discussion? That is very important. 5th of May 2022.
Whatever it is, please, yes.
Yes. Now that
Can we go into examine that?
If there is an illegality, my lord, your
No, please. That is not illegality. There is a note prepared. It's a decision taken by the cabinet. And normally we do not go into that. There are restrictions starting from the earlier, there are number of judgments dealing with it. Even Kishananda Bharti deals with it to that extent. We need not go into all that. Their facts are stated at that time in 2022. There were two views being floated around. There were certain irregularities noted. They then cabinet decided that let's take supernumerary posts.
whether Milord cabinet could decide Milord to
We will not be able to. We will not step into that question.
No, but I am not on the wisdom. I am on the question of constitutionality.
No, or even on constitutionality.
If the,
1 minute, please. Constitutionality aspect we have already decided and struck down that.
yes.
Now the question is whether the cabinet decision in this case should be referred to or made subject matter of CBI investigation. It's a decision taken by the cabinet as a whole.
Yes.
And on the aid and advice they have given the matter went to the governor. The governor has issued the order.
Right.
And succeed.
My Lord is probably
Sorry, we not.
asking the question about the CBI investigation.
That's all. That's
That-
the only limited essay.
It's
And
not
that is the reasoning given by the High Court is also
That's very
not really, not,
Para 257.
I've gone through that. It doesn't really, just,
the CBI investigation is called
I've
for.
seen that it doesn't go into all those aspects.
Para 257 only.
Should not in fact.
In fact, they were all illegal appointments, Milord. And that
1 minute, please. That's not the issue before the cabinet.
No, that is firstly.
No, Mr. Baninder Singh, that's not like,
Just give me 2 minutes, my lord, in my turn, whenever your lordship want to hear.
My lord.
I'll show from the cabinet. It is founded on.
okay.
Kindly come to the cabinet note.
Cabinet,
1 minute, 1 person at a time after he is over.
Yes, after letting me over, I
but
only need to.
cabinet decision will not is initiated by the school service committee, holding that the post be filled up for the waiting list candidate when admittedly the list was exhausted. As per the rules, there is no existence of waiting
They
list.
had the power to relax the rules and therefore
But they-
in terms of that they exercise.
Because they don't have the power Milord to create posts like
Okay.
that. Kindly comes to statutory rules once. Excuse me. I know Milord the limitation of the constitutional court not so far the directing investigation is concerned. But if the court's conscience is satisfied, which is satisfied in Ajna matter, this is absolutely per se illegal, unconstitutional. Here also, the cabinet memo was prepared only to ensure that the illegal appointees are protected. Whereas the rules permit the state to create supernumerary posts.
for illegal appointments.
Because the concept of supernumerary means, Lord is well aware, in a cadre service where the number is fixed, if someone else by chance is there, but he is beyond the strength of the cadre, then by a supernumerary post, that job person to the person is not secure. But here the supernumerary post to create a vacant post for the purpose of fresh recruitment. Whether that is as per the rules or whether the constitution
Do
permits.
you realize the consequences of your argument?
Hopefully so.
Sorry.
Lordship, only
1 minute, please let it
If-
be over.
if-
We will hear you, Mr. Baninder Singh.
I
You
wait.
know, the vacancies are to be created but should be kept
Okay,
open
we
for
have
all that
understood. We have
article.
understood. We have understood. Yes,
Your Lordship may kindly see, Milord, para 257 of the impugned judgment.
yes, please.
Because this Milord supernumerary post, Milord, should be read in inverted commas. I'll make good the argument, Milord. The Lordship may see, Milord, how the learned division bench, Milord, they read about the role of the state government. Para 257. The role of the state government in the writ petitions and the appeals that have been heard by us has to be taken into consideration. As has been noted before, SSC file CAN 6, and I will read this CAN for your Lordship's kind consideration, in writ petition number so and so, Milord. SSC, that is the commission,
Correct.
had prayed for creation of supernumerary posts. Very good till this extent. In respect of appointments given illegally. And this is the part of Can 6. And I will read the paragraph of an affidavit sworn by the Assistant Secretary of the Commission, which says that the supernumerary posts are for illegal appointments. I'll read that paragraph, Can 6. State government has not opposed such a prayer. In fact, documents placed on record suggest that the state government at the level of the cabinet had approved creation of the supernumerary post to accommodate the persons who had received employment illegally, and that is the word used in the application, in the set selection process. The principal secretary had appeared before the learned single judge and produced a cabinet note. Now, your lordship may kindly see page 265, para 265.
Yes.
May I read it?
Yes.
The state government therefore has accepted that there were widespread illegalities in the selection process and that the number of persons who had received appointments illegally could not be determined with exactitude. They had resolved to create supernumerary posts to accommodate the illegal appointees.
Look, this closes to the reason. What happened was there were certain candidates who were found to be tainted. On that, there was no difficulty. They themselves had removed them or even shunted them out without following the inquiry procedure. Number two, they were with the, at that time in 2022, they were of the view that we cannot now segregate who are the other tainted candidates. So in order to benefit the people who are on the waiting list, they said, let's create the please do not interrupt like
Yes,
this.
sir.
They created the supernumerary, they decided to create a supernumerary post, and the cabinet decision also says in the end, this is subject to the writ petitions already pending in the court.
Correct.
If that is so, how can you say that?
The reason may not I'll read it.
How is criminal investigation, that too by of a state government cabinet decision be taken by a central agency? Will it not defeat the entire purpose behind federalism?
Today will not be.
Until unless there is something much more, that too we'll have to examine in terms of articles of 74.1 and 74.2 and 163.3. We'll have to examine all that.
Today will not be great respect, my lord. Let us.
So, and this reasoning of the High Court dealing with the CBI inquiry with regard to that is hardly dealing with any legal issues. It doesn't even
So
examine.
two submissions on that, my lord. Your lordship may kindly see, my lord.
Anyway, we don't have to
Only
give
one
you
submission then. Only one.
Please answer this if you have.
Yes, I would, my lord. I just read, my lord, para 6 of Can 6, which is filed, my lord.
Yes, please. Which page?
Lord, it is in Can 6, my lord. It would be paragraph 5, my lord, because your lordship.
Can 6 is what?
Can 6, my lord, is an application on the basis of the cabinet decision.
That's a case for cabinet decision.
Correct.
Dated 5th of May 2022.
That is that, and they swore an affidavit to this extent on 27th of September 2020.
Which portion of that?
Yes, my lord. Now, your lordship may kindly see, my lord, if they want to come clean, then para 6 should not have been incorporated in this.
Yes.
In such circumstances, may I read para 6?
Yes.
In such circumstances,
Para 6 where?
para 6, my lord, of the application.
No, you don't read your application. Read the cabinet notice.
No, I would, my lord, but on the basis of this,
Okay, fine.
yeah, the application is preferred before the honorable court, my lord. So the application is filed on 27th of September, and para 6 is relevant.
Paragraph 6. Yes.
Lord,
Yes.
para 6, my lord.
The applicant states.
In such circumstances, my lord.
No.
It is, my lord, IA number 87607. It's the thin one.
We've got 87607.
Yes.
Paragraph 6 begins.
Para 6
The applicant
page 13, my
states
lord.
that such discrepancies and illegalities.
Page 13, my lord.
Yes.
My lord, may I read, my lord?
Yes.
In such circumstances, it is humbly proposed, your lordship have it, that apart from giving recommendation and appointment to genuine candidates as observed by this honorable court in other similar matters, supernumerary posts to be also created to accommodate those,
This is
if
wrong.
any, whose
This is
appointment.
wrong. This is absolutely wrong. This is not what the cabinet decision.
No, this is what
No, this is not what the cabinet.
No,
That's
where's the affidavit? No.
Just come to the cabinet decision.
I copy,
Come to the note. What's the cabinet note?
Page 15, my lord, it is sworn
Just
by the
one minute,
assistant
please.
secretary
I
of the commission.
have said this is wrong. If this was a purpose, it is wrong. Just come to the come to the page number 4 of the cabinet decision.
Cabinet.
Cabinet note.
Yes.
That was triggered by SSC.
Please, you have argued, do not interrupt now.
When I am not interrupting, I shall argue again.
So,
So,
you will intervene at your time, not at somebody else's time.
today, my lord, your lordship.
That the
say, my lord,
state government may be permitted to issue, just come to page number 4, paragraph number 3B.
B. The state government. May I read now? The state government may be permitted to issue necessary direction to the commission by invoking section 19 of the Act and to the West Bengal Board of Secondary Education in the interest of education in terms of Rule 3.2 of the Education Appointment so-and-so Rules 2018 for absorption of such waitlisted candidates in the proposed supernumerary post to be created with the approval of the cabinet. However, the same shall be subject to outcome of pending litigations before the Honorable Court.
Correct. So that was the object. And that's the reason why they have done it. And if you turn to the cabinet decision also, which is then
With
communicated.
great respect, my lord, there is no application filed that waitlisted candidates, my lord,
Sorry, please.
be accommodated, my lord.
Yes, Mr. Manan.
Today only one submission.
That's all, please.
Only
That's
half
all,
a
please.
minute.
That's over.
Today, your lordship.
So please, you have argued. Yes, Mr. Manan,
My lord, first submission. My lord, even the parliament, my lord, the legislative power or by power by the cabinet, my lord, on any issue, my lord, is founded on illegality noted in the note itself. Then that is a colorable exercise of power. That is complete absence of any bona fide, and the immunity and protection to the cabinet decision making, my lord, will not come into play. Kindly come to that cabinet note, the second para, para 2.
Yes.
If, my lord, if
Mr. Manan Singh, you are appearing for whom?
my lord, for the writ, petitioner, respond number 1, my lord.
Did you make that prayer in the writ petition?
I-
Did you make that prayer in the writ
This has
petition?
come during the proceeding.
No, please. Did you make that prayer in the writ petition? The when did they amended the writ petition?
My lord, kindly see, my lord.
Mr. Manan Singh, answer the question. Did you make that prayer in the writ petition? Yes or no?
At that time, it was not even.
Okay, fine. That we take it that the reason you're not answering it either way is you did not make.
Yes, my lord, it was. Now, may I just show that paragraph, my lord, to your lordship?
Okay, fine. Now the second argument. Can such a prayer or issue be?
That's what I'm answering, my lord. If, not just by 1 minute, my lord, your lordships have read the note, your lordships are asking me to read the note, only one paragraph.
Yes.
It is not, my lord, with utmost respect, not simple, my lord. There is a distinction, there is a bifurcation of a bona fide decision making and a decision making which is colorable. Now, my lord, the note itself is founded on the basis that there are appointments which are not in any list. Kindly have a look at para 2.
They are not defending those
That is
appointments.
not on appointment, my lord. If it says, if commissioner says, these appointments are required to be cancelled, they are out of no list. Kindly permit me to read 4 lines. The chairman, West Bengal Central, my lord, I am para 2, subclause 1.
Yes, please.
Subclause 1, my lord, and kindly come to subclause that unnumbered para.
Line jumping. The 5 to 6 number line jumping.
Can I read it? The chairman, West Bengal Central Service Commission, further later dated placed a report to the state government stating that there are 751 who are not in any list, either in panel or in wait list. The West Bengal Board of Secondary Education has also confirmed the fact of such appointment of non-teaching staff beyond the list as reported by the commission. The chairman of the commission further stated, for teaching posts of so-and-so who do not feature in any list, either in panel or in wait list, should be cancelled by the commission. Now, my lord, this is not one of the views. This is a factual position of illegality.
They are recommending cancellation.
No, my lord, kindly this.
What else do you require, Mr. Manan
My
Singh?
lord, if, my lord, please, my lord, visualize the situation that blatant illegality is noticed.
They are not condoning that.
No, my lord,
They are not asking you to condone that. They're not asking that it should be overlooked. All that they're saying is, now that the panel list is over, everything is over, we cannot now carry on further investigation. So let's accommodate the people on the waiting list so that they can be also given.
my lord, your
That,
lordship, 1 second, my lord.
that was the object.
My lord, 1 second. If, my lord,
How
if
can
they,
you attach criminality to it? I don't know.
1 second, your lordship would permit me, my lord.
Is
If
it so
they,
simple? Cabinet decision being.
my lord, if a cabinet decision note is,
You have argued that, Mr.
my lord,
I'm only saying factually this is not flowing from that.
my lord, this is that, there is a report, there is a letter. There is a report that this illegal admission must be cancelled. Lord, on this, the CAN 6 is filed. Lord, with utmost respect, if supposing the illegality is at the bottom of any decision making, admittedly, there is no dispute on this, that these appointments are illegally made from no list.
Okay, that Mr. Do you have to want to add anything, Mr.
Appointments have been made. Because I don't know what my management is.
Only one thing.
Only one submission.
With my lord's permission.
That I have filed an IA in connection with only one this matter.
The matter is over.
Kindly pardon, sir. Kindly pardon. We are not covered by the recruitment process. We are teachers who were appointed.
You are nobody then, please your listeners blind.
Work education, physical education, teachers not covered by this.
Okay, fine. Mr. Sybil, you want to add anything to what?
No appointments have been made under this cabinet because of those
Right.
in the wait list.
My lord will.
Just listen now, let us take one. That's when to our decision.
And under 163, your lordship is aware.
In terms of our decision, judgment, in terms of our judgment dated 3rd April 2025, white paragraph 52, which white paragraph 52 has held, observe, that the issue with regard to direction of investigation by the Central Bureau of Investigation is a decision to create supernumerary posts will be dealt with separately. We have heard learned counsel for the parties. Full stop. Next slide. In particular, our attention is drawn to paragraphs 257 and 265 of the impugned judgment. Full stop. Next page. We have considered the amendments made, the observations made in the said paragraph. Full stop. On a pointed question, it is accepted that the writ petition, no specific prayer,
Hello, now you can see me.
the cabinet decision, was the cabinet decision dated
Yes, you can.
19/5/2022, consequent to cabinet decision, consequent to which order dated 19/5/2022 was issued by the government of West Bengal after approval by the governor, was specifically challenged. Full stop. Neither was any prayer made that this order should be made subject matter of any investigation by the police or the Central Bureau of Investigation. Full stop. Next page. A perusal of the note dated, next page, 5th May 2022, which makes out the case for cabinet decision, would records that the power under section 19 of the West Bengal School Service Commission Act 1997 is being issued, may be issued in respect of wait-listed candidates, but the same shall be subject to the outcome of the pending litigation before the High Court of Calcutta. Stop. The cabinet note, the case for cabinet and the cabinet decision was taken at the time, which is accepted when there was there were pending litigations in the High Court and the possibility of finding out what tainted, finding out by thorough examination, the list of tainted candidates was not possible. Full stop. It is pertinent to note that the case for Cabinet Note, decision dated 5th May 2022, specifically mentions the view expressed by the Central School Service Commission that they were wrongly appointed candidates by way of rank jumping, etc. Nothing was hidden. Full stop. Next paragraph. Having regard to the aforesaid facts, having regard to the aforesaid discussion, we are of the view that the High Court was not justified in referring the issue of creation of supernumerary posts pursuant to the cabinet decision to investigation by the Central Bureau of Investigation. Just record one more thing. It may be relevant here to reproduce, to take note of clause 2 to Article 74 and clause 3 to Article 163, which specifically states that the question whether any, and if so what, advice was tendered by the Council of Ministers with the Prime Minister as his aide to aid and advice of the President. Advice was rendered by the council, by the ministers to the governor, shall not be inquired into in any court. The aforesaid direction is therefore set aside and quashed.
Only with respect to the investigation.
Pardon?
The minority is only part of investigation.
Pardon?
Washing the part of direction.
No, that's fine. Fine.
Nothing, but so for the pending matters are
No, we are not touching.
Yes.
We clarify that the directions, that our observations and directions given in this order are limited to the extent of the direction for investigation into creation of supernumerary posts and do not in any way impinge or reflect upon the investigation and the charge sheets filed by the Central Bureau of Investigation in other cases,
and also the
on other aspects.
and the pending repetition also.
Pardon?
And also it
Obviously, the repetition starts.
Well, that's why is my
record. Otherwise it will be confused.
That's so there is no confusion.
Very well.
deeply obliged. Deeply obliged.